This week's Brandon's blog is titled Mortgage Fraud in Canada. Canadian bankruptcy can't release you from a corrupt debt you created. This week, Brandon talks about a very recent decision from the Court of Appeal for Ontario. And it's about someone who committed mortgage fraud and then went bankrupt. And the purpose of this blog is to show you what the outcome will be. Now, there's two kinds of mortgage fraud. One is where the unsuspecting homeowner has their identity stolen and crooks are able to impersonate that person, borrow money against that person's property, never to be seen again, never to make a payment, and that person is left with a mortgage they never got the funds for in default. That's not the kind of mortgage fraud Brandon is talking about in this week's Brandon's blog. Rather, he's talking about where a homeowner or prospective homeowner making a mortgage application falsifies something because they know they would otherwise not qualify for the loan. And the Court of Appeal for Ontario case described in the blog below is a situation like that, except taken to the extreme. My name is Ira Smith, president of Ira Smith Trustee and Receiver Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to talk with you. I hope you can watch until the end of this video because I know you will find it informative. Brandon first talks about mortgage fraud and describes what it is. And interestingly enough, the Financial Services Commission of Ontario says that about 20% of all mortgage applicants perform some form of mortgage fraud. 1 in 5 people falsify something on their mortgage application. One person's white lie is another person's mortgage fraud. In the case that Brandon describes, and I'll tell you about in a minute, it really was fraud. Brandon talks about the most common schemes, the 3 most common schemes of mortgage fraud. The first one is when someone goes to buy a property and they say that they're going to be the owner occupant. They're really buying it as an investment to rent out, but it's very easy to say you're going to be an owner occupant. Why? Because the banks, the mortgage companies don't follow up. They don't check. They don't go to see who's living in the property once they advance the loan. So as long as you don't mind swearing an affidavit saying that you are going to live in that house, and then you really don't, that type of mortgage fraud is pretty easy to carry out. The second type of mortgage fraud is really the part of shady mortgage brokers or mortgage agents. And that's where they literally get false employment letters and doctor up T5 statements of employment income in order to tell the lender the person is making so much money, which is really a lot more than they're really making, because the mortgage broker knows the lender will never give the mortgage based on the amount of income the person is really making. And the third type of most common mortgage fraud is what Brandon calls the debt shell game. That's where you owe money to different credit card companies banks, whatever, and you get a loan from a family member in order to pay those off. And then you go to apply for a mortgage and say you don't have any debts. So all of a sudden, your financial picture looks a lot better than it really is. So those are the three main types of mortgage fraud that are most common. Now, what happened in the case that Brandon describes below is that the homeowner had a first mortgage, a second mortgage, and then Canada Revenue Agency went to federal court because the person owed a lot of income tax, about $500,000 or so, got judgment and registered against the home. So now the first mortgagee is really in second and the second is really in third, because the judgment under the Income Tax Act takes priority over everyone. So what the person did was he applied to the second mortgagee to advance him over $200,000, which he said was everything necessary to pay off Canada Revenue Agency. And he gave the name and phone number of the CRA tax collector to the representative of the second mortgagee to verify it. Well, it turns out that that person wasn't a tax collector at all. It was this man's friend. So they advanced the $250,000 and then found out later there was still over $300,000 owing to CRA, and they were still in third position. So they sued, and they asked the court to put in the judgment that the debt was fraud. He obtained the money fraudulently, and therefore the debt should survive any bankruptcy that he may make, that he may file. And the judge made that order. Now the man appeals that order. And the Court of Appeal for Ontario looked at it very carefully. And what they ended up deciding was it's very obvious from the evidence put forward by the mortgage lender that this man did commit fraud. He got the money under fraudulent pretenses. And therefore, that is one of the kinds of debt under Section 178(1) of the Bankruptcy and Insolvency Act that is not released when a person gets their discharge from bankruptcy. The Court of Appeal for Ontario said the lower court did not make any errors, and the court properly made the order that this is a debt that doesn't survive the discharge of this man's bankruptcy. What the Court of Appeal for Ontario says that if there's enough evidence in the pleadings to show that the debt you're suing for is one of the debts not released by a discharge from bankruptcy, you can get in the court order, even if you didn't originally get in it, the section that says that debt will not be released upon the discharge of the bankrupt. So I hope you can read the entire blog below, because I know you will get value from it. Again, both Brandon Smith and myself are available to answer any questions you may have. So shoot us a message, give us a phone call. We would love to talk with you.